petition to run for as an independent was passed a few days ago.
Okay. Okay, yeah, go on, carry on then, thank you.
Once the name is left off the ballot, that damage cannot be undone. Just today, the final list of candidates was posted. So that needs to be... There's still time to change it, but that needs to be remedied. Alright, the third item on the federal standard, the balance of harms. So, the harm to me and the fellow candidates is immediate and permanent, and there is no meaningful harm to the state or election officials if they are temporarily restrained from, sorry, let me rephrase. There's no harm to the state if they are temporarily restrained from withholding us from the ballot. At the end of the day, if we win the election, that just means the people were in our favor. I don't see the harm in allowing us to continue to run. They lose nothing by allowing the voters to a full set of candidates, while if we are not able to be granted access to the ballots, we can lose everything. The fourth and I believe final, the fourth and final standard for the federal standard is public interest. The public interest is best served by ensuring a fair election process. It's never in the interest of the public to deny a qualified candidate access to the ballot based on an unproven allegation or bureaucratic overreach. The TRO protects the voters as much as it protects me and the other candidates. Any questions, Your Honor?
No, I think you've summed it up. Well done.
Thank you. Yeah. Sorry for my nervousness.
No, completely understandable. Thank you very much. Is that it?
For now, Your Honor.
Great, thank you. Right, General, you're up.
Okay. Hold on. Alright, I'm ready. May it please the court, I respectfully oppose the plaintiff's request for a CRO. Plaintiffs bear the burden under Winter v. Natural Resources Defense Council to satisfy each of 4 demanding elements before this court should grant such extraordinary relief. The opinion is explicit. The movement must show that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. As to the first element, likelihood of success on the merits, the plaintiff's constitutional claims falter under well-settled analysis. Under Matthews v. Eldridge, procedural due process requires no single procedural checklist, but instead a 3-part balancing test. Courts must weigh 1, the importance of the interest at stake, 2, the risk of an erroneous deprivation of the interest because of the procedures used, and 3, the government's interest in limiting procedural burden, as well as the marginal benefit of additional safeguards. Here, plaintiff's alleged interest stems from a state-issued business license, not a fundamental right of candidacy or citizenship. That this is all coming from their application for the TRO. Mayflower law already provides a pre-revocation notice, prompt review, and appeal. The state's compelling interest stands in the need to prevent money laundering, preserve electoral integrity, and maintain public confidence in the political process.
Can I intervene here? There isn't the fundamental right here the First Amendment, so the right to freedom of expression and assembly. Is this not the case here?
Your Honor, if I may,
please go on.
Interject.
Yeah.
The Solicitor General alluded to the fact that there were no rights violated. Under Mayflower law, having a business is a statutory right, and the Secretary of State may not deny anyone for having a business unless they're specifically enumerated in that part of the state code under Chapter 2 of Title 4.
Okay, so...
Wait, can you repeat that? I was reading something.
Go on.
Bob, if you could repeat that.
Yeah, so the owning a business is a statutory right in the state of Mayflower.
Hmm.
That's what I
Well,
was saying in response
where's
to
the
what you're saying.
statutory right? Can you read it out in the section bit, please?
Yes. One moment. Let me. The Secretary of State shall refuse to file articles of incorporation if it does not meet the following standards, and then it enumerates standards. And then the Secretary of State shall refuse to file an article of general partnership if it does not meet the following standards, and then four more standards. That covers all types of businesses. Under that, it's kind of implied, Your Honor, that if it meets those standards, he can't refuse to file it.
Okay,
Therefore, making a business a statutory right under the state of Mayflower.
so it's an implied right, basically, is what you're saying.
Yes, Your Honor.
Okay. Did you get that, General?
Is my mic better? Everyone's saying it's quiet. Is
Yeah,
that better?
yes, yeah, you're much better now. You're much better, yes.
All right. Hold on. Can you talk real quick? Like it messed with my headphones.
Hello? Hello? Can you hear me?
All right, it's better. Yeah, it's better.
Great, great, great. So can I ask you a question then? You said there's no
Yeah.
fundamental right. If I say that the fundamental right is freedom of association, and then I'd apply strict scrutiny to this and say that due process is required, what's your reply to that?
Wait, can you say that again? Sorry.
So, if the standard, so obviously to apply strict scrutiny, you have to have a fundamental right in question, and then the measure needs to be narrowly tailored. If I said that the fundamental right is freedom of expression or assembly or association, whatever one it is, because that's already recognised as a fundamental right. And then I say that this measure is if I say that the measure is not narrowly tailored, because the executive shouldn't be able to take away someone's license without sort of due process. What's your reply to that? Is that sort of the wrong sort of way to go about this?
Yeah, so the First Amendment protects the rights of citizens to associate. So this is from case law, to associate and to form political parties for the advancement of common political goals and ideas. That's from Colorado Republican Federal Campaign versus Federal Election Commission. States may enact reasonable regulations of parties, elections, and ballots to reduce election and campaign-related disorder. Burdick v. Takushi. So
Okay.
the Columbia First Party was activated pursuant to 12 MSC 2 subsection 4101D.
So
let me pull
say
that up.
that again. Say that again.
Let me pull up the statute. I'll read it out.
Yeah, please.
I gotta open it. I just want to say that they can still have their party even without the license, and there has never ever been
the Mayflower election
that
rules.
states can't regulate political parties. So,
Your Honor, the Mayflower election rules prohibit a political party from being, a political party unless it's a registered business.
Okay.
It's been this way for the longest time.
Okay.
Where is that? Where does it say that? Can you make that a little?
I'm just going off the top of my head. Let me check the MEC Discord. That was the last I heard of it, and they disqualified us because.
Check the rules, the code, electoral code under Title 12.
The MEC revoked it for losing their business license. The official statement is the notice of party status change. On August 3rd, 2025, the Secretary of State informed the MEC that the Columbia First Party has lost their business license. Under 12 MSC 2, Section 4101D, a business license is inter alia required to keep an active registration with the Commission. They revoked it because we lost our business license.
Right. Okay. And so is your argument then that the response was unreasonable and or excessive? Is that the argument in a nutshell?
Yes, Your Honor. We're also arguing that by removing the business license, it's violating our right to association.
Mm. Okay. Okay, so, General, let me ask you point blank then. Was this unreasonable and excessive? Because I don't know how on earth it can be reasonable or non-excessive for the executive branch to take away or delete effectively a political party overnight and dump a load of people who are registered to go on the ballot a day or two before. I don't know how that's reasonable.
Well, respectfully, no. I mean, what happened here wasn't a punitive act. It was an automatic consequence of non-compliance with the statutory financial disclosure requirements. The statute doesn't give the Secretary of State discretion to overlook violations. It says clearly if a party fails to file for 30 days, it loses its recognition, and with that, it loses access to the ballot. That's not excessive.
What is he talking about? Filing for 30 days? Could you
You
clarify?
were bringing up financial in your complaint and your CRO, and in your argument, you brought up the for MEC 6 section 22202 and 2203.
Yeah.
And under their rules, which you automatically agree to when filing for a business license, it says under section 1.1, business ownership requirements, the owner must not participate in organized crime within the past 15 days. And below that, it says in a sub-bulletin point, the owners must not engage in organized crime. Dog owning a business, engaging in organized crime. The owners must not engage in organized crime while owning a business. Engaging in organized crime will result in the deregistering of said business.
Your Honor, by the Department of State's own, by the Department of State's own regulation, the person who was not even found guilty, so you can't say he was participating in organized crime because he wasn't even found guilty yet, wasn't even the owner. He was just a high rank in the party.
Further,
Daniel Crusoe is the owner of the party, not Willie McNoble.
So, General, if someone else from the opposite party, is this the justification? So, if someone else, I don't know, my alt, goes and kills a bunch of people and participates in racketeering or something, joins the opposite party, so the party that's still active, I don't know what it is, and gets a high rank, can that party be deregistered at the will of the Secretary of State without any sort of conviction?
I mean, it seems so. This is the precedent they're setting, Your Honor. And additionally, I'd like to point out the investigation led by the MBI, led by the head of the MBI, Director Just Dapper, is also a political candidate for the opposition party.
But what? Is that true?
Yeah. Just Dapper is running for Senate under the Mayflower United political platform, and I'm 90% sure he either led or oversaw the entire investigation into Willie McNoble.
Okay. So... Okay, the Solicitor General's just saying he's got some problems with his mic. Okay, I'll question you for a bit until he's back. So go over this again. The opposition, or a member of the opposite political party, is running for office and is in charge of, or basically facilitated, deregistering the other political party by investigating them and criminally charging them. Is that right?
Yes, to my knowledge, Your Honor. The director of the Mayflower Bureau of Investigation, who is running for state senate under the opposition party, oversaw or led the investigation into Willie McNoble, upon which recommended to the Secretary of State that the Columbia First Party license be revoked for a non-owner of the business committing a crime, thus leading to the disqualification of all of the party's candidates.
Okay, this sounds
Dapper isn't the director. I was just informed. I believe he's deputy director, but that's still
Deputy.
a major.
Yeah, that seems like a conflict of interest if there was one. Okay, the Solicitor General just asked for 5 minutes. Hello? Who's speaking? Solicitor? Oh.
Yeah,
do you still need 5 minutes?
Yeah, give me 5 minutes. Let me gather my thoughts. I think I should have prepared a little more for this.
No, that's fine. Okay, well we'll go in recess for 5 minutes and then we'll come back. Okay. See you in 5 minutes then.
got anything further? Got anything further?
Alright, hello. Axe Mike Berg, so I'll be speaking for him if that's fine with you, Mr. Alex, or Your Honor.
Oh, okay, your replacement counsel. Yeah?
Not necessarily. His microphone is like, it's just not working, so he's invited me to his document, and then I'll be assisting and just reading it off and answering the questions that are posed to him, just for the live stream or whatever such.
Okay, that's fine then.
Your Honor.
Yeah. Go on.
Sorry, I have a statement to make once we're back in session.
Okay. Let's have a think. Right. I think we should be back in time now anyway, so we can come out of recess anyway.
Alright.
Let's have a look. Okay. Okay, I'm happy for a statement then. I'm happy for your statement then, Bob, and then we'll go to defense.
All right, so Your Honor, adding on to what I was just saying about Dapper leading this investigation, it's also been directed to my attention that Just Dapper is the Inspector General for the Department of State.
Okay.
I was just tased.
Wait, what?
I just got tased.
There was a subject who ran and he got tased in the crossfire.
Oh. That's great.
But Just Dapper being the Inspector General is policing the Department of State, allowing them to, commit these illegal acts, whilst also leading, the clearly biased investigation which caused the revocation. That's all I gotta say.
And can I ask a question of defense? Do you know when this investigation began?
I do. You just give me 1 minute, I can pull up the transcript, and then I have a statement to make after that if you
Great, yeah.
would allow that, Your Honor. The investigation began July 23rd, 2025 at 2200 hours Eastern Standard Time.
Okay, and when did the registration period for independence close?
I'm not entirely too sure, Your Honor. Let me see if accuracy.
I believe 2-3 days ago. I believe 2-3 days ago, Your Honor. But we had no knowledge of an investigation until the suspension and conviction or charges, I should say.
Right. So that it was conveniently released a couple days after the registration period closed, and where everyone on that ballot for that party would be kicked off. Is that true?
Yes,
Well-
Your Honor.
Okay.
We also have Discord messages of their top secret informant being told by the party owner not to embezzle money. He was, doing stuff on his alt account, as most people do in this game. And he was told not to embezzle money by the party owner.
Your Honor.
And he obviously did something behind us all with Willie McNoble, but that's another point.
Yes.
Your Honor, the party owner, Daniel Crusoe, was aware of the actions. We actually have messages sent to a MBI special agent of Daniel Crusoe being aware that the informant, the state's informant, he was aware that there was the talks of money laundering going on. If you provide me access to the case channel, I'll disclose it. But he admitted it to a special agent's direct messages that he was aware, and there was a conversation that had happened. So he was aware that there was a conversation, at least a conversation that it was happening, and then it proceeded to evolve into actual full-fledged money laundering. So the notion that the party leader had no idea what was going on is simply untrue and is a lie from the plaintiff here.
No, Your Honor. The party leader had no knowledge of the money laundering after what he said not to do. I can read off the messages and I will admit it into the case channel. Let me open it 1 second.
Okay. Well,
And then if you could provide me the access, I'll send my screenshot.
yeah. Okay. Well, the
It's
facts
been
are very
posted.
interesting. Yeah, the facts
I'll
are
read
very
it off. The state's informant was asking about money laundering. The party owner said, "Hey, yes, I'd like 1 felony charge." And then his last message is, "Ollie, if we money launder, that'll 100% or 1,000% backfire." He was telling him not to do it.
Okay.
But is the business owner still not responsible for his employees? He had knowledge that they wanted to do it, and then they proceeded to do it. This was a senior party leader. This wasn't just a staffer. This was a senior party leader who was money laundering into it to campaign for the party.
Okay, just a second.
Regardless of whether he had knowledge, first of all, it's not the business. It's donations. It's not his job to look into where donations are
Okay.
getting their money sourced from. He's not a
think
private
we have
investigator.
counsel for
But
the
regardless, sorry, Your
Just a
Honor.
second.
Hello?
Hello, can you hear?
Hi, how are you?
Excellent. How are you, Counsel, Mr. Paxton?
I'm doing amazing. I am here as sort of a secondary counsel, like a little limited appearance for the defendant. I would like to just kind of take a step back and reframe. Sorry?
Please go ahead.
Okay, I would like to take a step back and kind of reframe this issue where it's not so much that it's them being disqualified, it's they ran under a now invalid party, and obviously we know, going back to like 1970s, 1990, and Store versus Brown, Timmons versus Twin Cities Party, states have broad discretion to regulate ballot access. This really is just a ballot access issue. And the party that let them on the ballot is now invalid. They were found to be various different campaign finance violations, criminal activities. And the reason that they can't be on the ballot is because, obviously, like I said, this invalid party nominated them, and they don't have the requisites for an independent petition. So that's all I have to say.
Your Honor, if I may respond.
And I welcome your questions.
Okay. Yeah, go on then, Bob.
By the time the revocation of the business license had come, it was already too late to file to run as an independent. First of all.
Hello?
Second of all, this isn't an issue of ballot access. All of the candidates were certified by the Mayflower Electoral Commission and were qualified candidates. It's an issue of the business license being revoked without due process and illegally.
Yeah. Yeah. Do you have anything
I have
to
a
say
response to that again.
Yeah.
Yeah, I do. So, number one, as was said earlier, when they got their business license, right, they agreed to all the regulations that the Department of State put out. And this also includes when they ran for election, they agreed to all the MEC guidelines, which included that they wouldn't violate campaign finance rules, but they did it anyway. And then there's also the matter of, they say it's not a ballot access issue. It is a ballot access issue. They're asking to be restored, but they can't because they were nominated, like I said, once again, under an invalid party that broke campaign finance rules. No other party did this, by the way. It was millions of dollars. And we're now past the deadline, and frankly, it's like...
My question is who gets to
Sorry,
decide?
say again?
My question is who gets to decide if they're guilty of this? Is it the courts, or does
it was
person get to shut down
so
the party?
in real life, right? The FEC investigates federal campaign finance violations, then they refer it down to the State Board of Elections. There are multiple times, I think please don't interrupt me, please, thank you. And then in the 1990s, there was a party in New York, or in the 80s, they had like 3 people on their board who were charged with fraud. They were referred by the FEC to the State Board of Elections. Their candidates were disqualified, and then later on, I think they challenged, but it was just too late, so it was moot. And then that's kind of just how this goes. Like the MEC made this decision. The MEC saw the evidence, they made the decision, and also just by entering into this election, the Columbia First Party agreed to all the MEC guidelines, which, like I said, for the 1,000th time, includes not violating campaign finance guidelines.
Your Honor,
as for a matter of due process, excuse me, as for a matter of due process, they're not making a facial challenge to the business license challenge, so that is an issue that's not right for judgment.
Your Honor.
Okay, go.
If I may, Your Honor.
Yeah, go on.
First of all, there was no rule broken of the MEC rules besides the business license status being invalidated. I don't know what he's talking about. Campaign finance rules. There was no MEC rule broken. It was a Department of State rule set by the Secretary of State. Okay. It says organized crime. And we've been over this, that the statutes in the Mayflower State Code explicitly state that they cannot be unreasonable requirements of businesses. And trying someone without an actual trial, determining they're guilty without that being decided by a court of law, is absolutely 100% unreasonable. They're revoking it
Once
preliminary,
once he's finished, I can respond to
preliminarily,
this.
without
Sorry, please
any
continue.
without any court, adjudicating this.
Yeah, can I just point out what my issue is here? So again, I think the real issue here is it unreasonable and is it excessive for an individual to shut down a political party or two individuals to shut down a political party and judge someone to be guilty of something or say that they're in violation of a criminal law without it and a conviction in the first place? That's really what I
So,
want to know.
is this projected toward me or him?
Yes,
or
to
either?
you, yeah. Thank you.
Okay. So they're not declared guilty of anything. This is just this case this case in essence is boiled down to, does the MEC have a mandate to investigate violations of campaign finance? They do. They have a specific and legitimate governmental interest in ensuring that people don't violate campaign rules, as was done here. And then, if the MEC is not allowed to take action, then anyone can just run roughshod and embezzle millions of dollars, right? And again, let's sorry, not to interrupt. They can still, as an adjacent, their party is not shut down. They can still assemble. They can still associate. The only issue is they can't get ballot access because they violated the rules for this election. That's just how it is. And
Your Honor,
we are
there
now.
was no campaign finance rule broken. He's yet to list
there
a
is.
single rule from the
There
MEC.
Okay, can we
What
Your
rule
Honor.
from the MEC? The announcement from the
Can you
MEC.
please let the judge speak? Thank you.
I don't care about the finance, whatever rule. All I'm interested in is, you said something about them being able to freely associate anyone. Wasn't the party just obliterated by one person or by the Secretary of State? That's what
Well,
happened.
Truth be told, I would like to know.
They can associate colloquially, but as a political party they can't really associate, and surely that's a deprivation, isn't it?
Well, not necessarily, because truth be told, political parties are, in essence, they're more abstract than concrete. So yes, you have local rules, state laws regulating them, and yes, you need to. Well, okay. In essence, let's separate the two, right? You have the governed side, which is like the side of the party that agrees to, in exchange for ballot access, they'll follow all of the laws, all of the MEC regulations. Then you have the abstract, which is just the party in fact, which is all the people outside, like just the membership in general. And then to actually effectuate their party, they need to be following the rules. But they even if they don't have the concrete part, which is, which we now allege that they have, like we said, violated the rules, so that part's out of the window. They can still associate in the abstract sense. So there's no association being trampled on here. The association, they did that to the concrete association, they did that to themselves. Okay, they broke the rules. The MEC is within its right to investigate and adjudicate these. Please, let me finish. The MEC is allowed to investigate and adjudicate these, just like the federal FEC is, just like State Board of Elections, just like for years and years, the government has a compelling interest in regulating elections and putting out rules and laws governing campaign finance. It's been that way since, look at Citizens United, So, whatever questions you might have.
Why aren't they entitled to due process before the courts, or even before the agency itself, Why is that not required?
Well, I mean, could you rephrase the question? I'm not exactly sure what you're asking me.
So they weren't given the opportunity to respond to this request or make representations, maybe why they shouldn't be removed, make any legal arguments to the agency. Why is that not required? Why do they not have some sort of due process interest there?
Well, I mean, in essence, what process are they due? Like, what are you asking? Are you asking for a trial?
Well, maybe even just the ability to make representations, because they're shutting down a political party at the end of the day. I don't know how many people vote for this.
They're not shutting it down. Like I said, it's just in essence, you have multiple things to consider here for issuing a TRO, right? Are they likely to succeed on the merits? Is there irreparable harm? And we contest that as we have alleged by sworn affidavit by the MBI, they would not be likely to succeed on the merits, and if anything, they would lose on the merits if we show, by contrast to their claim, they are going to have to essentially exonerate their party in this case to win this case at the end. But we have, by contrast, is evidence of their wrongdoing on a massive scale, millions of dollars. So in this case, their only way forward is to exonerate themselves.
Well, isn't this sort of burden on the state agency or the State Department actually prove that they've done wrongdoing, not to assert that they've done wrongdoing? They say defend yourself. You know, that's not really the way it works, is it?
Well, I'm not quite sure what you're asking me, because it's not like the Columbia First Party came into this election and said, you know, we're just gonna put all our candidates on the ballot. You know, we're not gonna follow any of the rules. We have these rules, but you know, at the same time, we're gonna break them. Okay. And by the way, this challenge is not attacking the underlying business license revocation scheme. So, and that's a majority of what they're hinging on. So I even said earlier that issue is not really ripe for judgment at all. If there
Your
was
Honor,
to be
objection. What he's saying is
that.
completely untrue. Literally, Section B of the TRO enjoined the defendants from taking any further action against Columbia First Party that would interfere with the. Oh, wait, no, sorry, it's the first part. Yeah, Section C. Reinstate the business license of Columbia First Party. That's Section C of the TRO. And that's a major part of the civil complaint we filed. And if I may continue to speak, Your Honor, what he was saying is completely irrelevant. First of all, the only rule that the Columbia First Party broke was having an invalid license, which in of itself, the license revocation was illegal. He keeps trying to shift to federal election rules, Mayflower election rules. That was the only reason given for the revocation of the party status by the Mayflower Electoral Commission. There was no campaign finance violation, as he says, and by the state's own standard, the Secretary of State's rules, it says that the business owner, the thing they charged us with, the business owner must commit organized crime. The business owner did not even commit organized crime. Allegedly, Willie McNoble, who is not an owner of the business, committed the crime.
Well, if I might add, the MEC's rule, their role here was ministerial. They were just following the DOS's guidance. So the MEC, by extension of the DOS, had to withdraw them because they were now from a disqualified party. And then look, this case is just going to hinge back on what I said, right? They're going to have to prove they are going to have to prove their innocence in this. And if there's anything that might be done, it is not going to be restoring the Columbia First Party to the ballot. Not in this hearing, not later on. It is going to be, if anything, we somehow extend the guideline to let them independently petition. But at the end of the day, there is compelling evidence, which goes to it's the second or third prong of the TRO, which is going to be at issue here, which is that there has to be a significant chance that you win on the merits, right? They have to exonerate themselves, which they won't be able to do that.
Your Honor, even if Willie McNoble is considered a party member or an owner of the party, which he's not, which by the Department of State's own guidelines, they can't revoke the business license if he's not the owner of the party. Even if they somehow find a way to consider him as an owner of the party, it still has to be adjudicated in court. It's not the Department of State job, it's not an executive cabinet's job to say, hey, that we think you're guilty of a crime, you're guilty of a crime now. This isn't France, you're not guilty until proven innocent.
That's just not what happened, though. There was, you're not convicted of a crime,
exactly
but you're allowed to be. The MEC is allowed to enforce their rules, just like the FEC, just like every single election body.
The issue is with the Department of State. The Department of State is a named defendant in this issue.
The Department of State is allowed to enforce its rules. It's like how the ATF can classify, a AR-15 as an automatic weapon if they want to. This is what the Senate gave them power to do. And this has been upheld in many cases.
The Department of State's rules is unconstitutional.
Please let me finish. By extension, these agencies can use the power that the Senate gave them to make their own rules and enforce their own rules. They have a mandate to do this.
Okay. Right. Okay. Can we move on to closing arguments then? I think.
Your Honor, if I could make like one final statement. There's a lot that's been like stated
My
by the
phone is
plaintiff that I'd like to
on
respond to.
Yeah. Go on then. Quickly then.
Okay. So throughout the dialogue here, the plaintiff has stated that they didn't break any electoral code rules, although subchapter 2 discipline 12 MSC 4203 specifically goes over finances and goes over that they may collect donations, membership dues, or other forms of monetary payments, but no expenditures shall be payable for salaries or non-campaign related expenses. And it goes on to say, except where otherwise listed, all members of a political party are jointly liable for improper use of campaign finances. Mr. Willick Noble, a senior party official, improperly used campaign finances, which is an MEC violation. They are more within their rights to remove them from the ballot. This has been a very continuous argument from the plaintiff. He's kind of like threw it in there every time he's spoken. Additionally, the candidates were aware of illegal activity. There was a specific candidate, I think their name was Sedative, who specifically left and filed a report with the Mayflower Bureau of Investigations in regards to the criminal activity they themselves, as a candidate with that political party, were aware of. It's simply untrue that they're saying that Daniel couldn't have known when simple people who are the simple candidates in their party were aware and were independently leaving prior to the due date. They were leaving and running by themselves. That candidate, Sedative, is independently running. They were more than aware of what they were doing. Daniel knew what they were doing. Willie knew what they were doing. Willie is a senior party official. In sense, I would argue they're an owner. I'm not the biggest legal mind, but I'd argue it. But the ordeal that the plaintiff is pushing forward is simply untrue. They violated Department of State rules. If I could just 1 second here to scroll up and find it. 1.1 business ownership requirements. The owner must not participate in organized crime within the past 15 days. Again, as a senior party official, through the messages that were even shown, Daniel Crusoe was aware and participated by allowing that employee to continue. Additionally, 2.4 dishonest business practices. Dishonest business practices shall be considered the conduct of any business practice that would other be operational in a way that scams, extorts, or otherwise falsifies its clients into the conduction of businesses. 2.3 Operation of a criminal business. The continual commission of other crimes as defined by the Mayflower Criminal Code in any form while representing the business or using its property as a front, included it was suspended, not completely disregarded. There is, quite frankly, they were aware what they were doing, and the fact that the plaintiff is continuously arguing that the owner, or the quote sole owner, was unaware of it is simply just a fallacy. It can't be true. As I said, if you provide me access to the case channel, I'll provide the screenshot that I'll be personally playing between a conversation with Daniel and a bureau investigator. Additionally, there was a talk that the deputy director, Just Dapper, was involved in the investigation process with the bureau. But again, if they were arguing that and they claim that they are aware of this, I'd encourage the plaintiff to provide any source of proof. It's physically impossible.
We're going way too far. We're going way over.
Your Honor, may I respond to that just really quickly?
No, I don't want to respond
This
to
is
that.
quite
I'm
important,
closing
Your
arguments,
Honor.
actually. No.
We can talk about it. This is just for the TRO. We can argue facts later.
Okay. So, give me the closing arguments now. You both have 3 minutes, and then I want to make a decision by half past. Okay.
Your Honor, can me and Sato split it up? We want to both say something to close.
He's gonna go first.
Yeah, as long as you don't talk for America. Yeah, you don't go over 5 minutes.
So,
seriously,
alright.
I'll just know to stop. So,
Your Honor, I'd like
ahead.
to make a verbal motion before we continue.
oh my God.
Please, just let him. Please,
Okay,
just
go
let
on.
him speak.
I'd like to make a motion to strike the everything the T4K3MW
Oh my
guy said.
God.
He's not a bar certified attorney under the state of Mayflower, to my knowledge. I see no bar certified attorney role.
I was
I'm not permitted
speaking
to make
for.
arguments, so
He was
No,
just
I was
speaking. He
frank,
wasn't
it's-
making
yeah,
arguments.
his mic
He
was
just
broken,
speaking to
yeah.
me.
Actors
I'm on my
has
phone
been
now.
able to speak for quite a while again.
no, his mic was broken.
You
I was
can
on my
excuse
phone.
the initial thing. You can excuse the initial part, but after actors started speaking again, everything he said is just an argument now.
Please control
No,
yourself, man. Thank you.
I had to
Thank
join
you.
on my phone.
Okay, be quiet.
Anyways,
Okay, I'm not interested in that. Let's just get to the closing arguments, please. 5 minutes each. Go on, Bob. You're up.
Your Honor, the facts are quite simple. They keep trying to shift to the MEC rules or to the to this thing or that thing. The MEC rules, they're not applicable because the Mayflower Electoral Commission did not revoke for any MEC violation. They revoked because the party's business license status got revoked. So whatever they were saying about the MEC rules, I ask you to disregard that. Secondly, the status of the business license being revoked is in of itself illegal. It is not the place of a cabinet department to revoke or no. It's not the business of a cabinet department to decide you're guilty and then revoke, as they claim. They're saying that it's their duty to say XYZ committed a crime, so that his business license must be invalidated. And their argument about the so let me rephrase. The argument about the political party status relating to the shared liability only relates to its status as a political party. This was taken in its action as a business liability, not or a business action, not a political action. The latter would only be true if it were taken by an MEC action, in which they would be jointly liable. Finalizing what I'm gonna say, Your Honor. We've already talked about the public interest, and I'm sure you're quite bored of us yelling at each other for now. But everything that they've set up until now has been a mere distraction from the facts. The right of the people to be able to vote how they want to in this election is being infringed by the Department of State's illegal actions and violating our due process rights. Not only did they find someone guilty without that being adjudicated in a court of law, they also failed to provide any any platform to appeal this before the business license was revoked. This caused damage to the plaintiffs, to the owner's reputation, and damage to the party as a whole. I yield, Your Honor. I rest.
Great, thank you. Thanks, Bob. Defense counsel, go ahead when you're ready.
Your Honor, the facts are not complicated. The defendants are trying to misdirect this court to shift the conversation from what actually happened to a set of rules that do not govern this case. They keep pointing out to the MEC. I'm just
Nigga.
let me be clear. No court convict. What the hell? Yo, just letting you know, never use ChatGPT to do your closing. Tyler, you can go ahead.
All right. Okay. That kind of threw me off, but anyways, so in many cases, right, in addition to answering the question of what process are they due, because that's just putting aside what I said earlier about the facts, about how they can't show success on the merits because they essentially have to prove their innocence here. That is how they win this case. They brought this case. The burden is on the plaintiff to show their innocence. Anyways, putting that aside, pre-suspension process is, in essence, allowed, and this has been upheld over and over again, where the public interest requires it. For example, here, where a political party is cheating on a massive scale by embellishing itself with over $1 million, the public interest undoubtedly requires that. You look at cases like Gilbert versus Omar, and even examples like in 2021 or 2022, when the GameStop stock was floating upwards off the Wall Street bets, you had the SEC shut off trading immediately. There was lawsuits about that. They said no, the SEC has a compelling interest in stopping people from trading, even though it's their money. They're holding the stock. It's technically their property. No, the SEC had a compelling interest in stopping them from floating up the value of the stock and distorting the rest of the market. The same thing, the same principle, not the same facts, applies here. the MEC has a compelling interest in stopping people at the buck from distorting the results of an election by cheating. It's what it is. It's cheating. The other issue is the Columbia First Party, as a result of where the public interest requires it, they then presumably had adequate process, and then they also had access to appeal mechanisms like whether it be requesting the MEC expand their waiver of immunity, but they didn't do that. So I point to cases like Hudson versus Palmer, FDIC versus Mallon, Gilbert versus Omar. They all say the same thing here, where the public interest requires it, due process is satisfied. In essence, where we have individualized evidence of severe wrongdoing, and the MEC has a compelling interest in enforcing their rules and their regulations and the laws that the Senate put out. And that's all that I have to say about that.
Okay, thank you. Thank you very much, Counsel. You'll probably hear back from me in about 10 minutes. We'll go into recess for about 10 minutes, and then we can kind of come back and you can listen to my decision. Is that okay?
Thank you, Your Honor.
Great, thanks, guys.
Yep.
Give me 1 minute.
You hurry the fuck up.
No, Sato, that's no way to talk to a judge.
I'm sorry.
You got anything further? 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 You got anything further?
Okay, we ready? Sorry about that.
Yes, Your Honor.
I'm gonna deliver reasons briefly, orally, and then a written order will be released tomorrow. Okay? Let me get a cup of water. Right. Let's get going. Right, what does this person want? Who's this? Okay, yeah, okay, sit them down. I don't really care. Anyway. Okay, I've decided to make a ruling. This is an all ruling on the TRO. And I'm going to rule in favour of the petitioner. To an extent, and I'll explain that just briefly. So under the winter standard, there's obviously 4 standards. Whether the petitioner is likely to succeed on the merits, whether they'll suffer irreparable harm without relief, whether the balance of equities favour the petitioner, and whether an injunction is in the public interest, and I'm satisfied that all of the four standards suffice here. I'm satisfied that the movement is likely to succeed on the merits. I believe there are serious due process concerns here related to a singular person or the singular exercise of an executive official or exercising ministerial powers, simply eliminating or deregistering an entire political party at will without any sorts of representations or court involvement beforehand. I'm also satisfied that there are likely improper purposes behind that need to be examined, and there are also separation of power concerns behind that also be examined, and that the petitioner will likely succeed on. The movement will also suffer irreparable harm because there will be statewide mass disenfranchisement. Individuals will lack candidates to vote for, and individuals and candidates who have campaigned over the past election cycle will simply not appear on the ballot, and only, I think, a singular party will appear. I intend, however, to narrowly grant the TRO to fit the circumstances here. I am not going to order the reinstatement or registering of the political party. I'm going to simply say that those who were represented by the Columbia First Party will be on the ballot as independents. I think that's necessary, and that aligns with the TRO's purpose to preserve the status quo. I'm confident that the balance of equities favours the petitioner for the above reasons, and an injunction is in the public interest for disenfranchisement reasons as named above. For the following reasons, the TRO is narrowly granted in favour of the petitioner. Does anyone have any questions?
No, Your Honor.
Number one, I would like a date for how long the TRO would last, and then a date for the preliminary injunction hearing, and then that's really it.
Do you know the I haven't read the rules recently.
Well, actually, this
Do you know
is probably going to be moot in a couple days. All that needs to be done is just put them on the ballot as independents, and then actually, I take that back. Some of the issues will be moot, but they didn't challenge. Did they challenge their suspension of their license as well, or was it just the ballot?
Oh yeah.
Maybe Bob can answer.
In the civil complaint, one of our stipulations is that our the MEC reinstate the party and the DOS reinstate the license.
Okay.
Okay, so this only goes to the MEC thing. So that's going to be moot after the election, but they're going to be able to run as independents, which we're fine with. We just want a date for the preliminary injunction hearing, which I may not be appearing anymore. I just did this limited appearance for this hearing, but
okay.
That's all I asked for.
When does the rule say that this needs to be done? Is it 14 days, or is it probably before then? A lot.
I would say 14, just because it's Roblox.
Yeah. We can schedule it for, I don't know, 48 hours from now if they want it. If state's fine with that, 48 hours for the PI hearing.
I'm good with that.
Well, I would just like to note that during that hearing, it will be about the facts as they were before this case, and not necessarily if they're due any process now. That's just what I'm going to add.
Yeah.
Okay.
We agree.
Okay. So 48 hours from now. When does the election end? I don't know when the election is.
I don't
Like
think
in 2 days.
I'll set a date yet.
Okay, so 48 hours. Okay. And when does the election open? Is it tonight or tomorrow? Anyone?
Like the 5th, probably.
Okay. Okay.
So there's not really a timeline you could say if you. I mean, they're running as independents, so they pretty much got what they wanted. So, and we're fine with that, actually. We were just concerned about the party itself.
Yeah, I don't think it would be wise to sort of reinstate and then unreinstate. Yeah. So I think this is a better sort of compromise. If everyone's
No, I
happy with
agree.
that.
I made that point earlier. Yeah.
Great. Well, thank you guys. That was very eventful and very interesting.
Yep. Thank you.
Great. Good luck. And just for
Thank you,
so
Your
everyone
Honor.
understands, for the public and audience, basically what I've just said is the Mayflower. What's it? Mayflower United. All the individuals on the
Columbia
ballot
First.
will be Mayflower First. Sorry, I made yeah. Sorry.
That's the opposition party, Your Honor.
Yes. Mayflower First. All their candidates will be registered as independents on the ballot rather than under the party name. That's the only sort of differentiation than would have happened before. Apart from that, that should be fine, and then we'll have the preliminary injunction hearing 48 hours, see where we go from there. Great. Okay, is that fine with everyone?
Yes, Your Honor. We're extremely happy with the outcome.
Okay, great. Thanks, everyone. Good night then. Bye.